Right, that's said, that done. The first case is the Law Office of Herssein and Herssein versus the United States Automobile Association.
Good morning, Chief Justice Labarga, members of the court. May it please the court, my name is Maury Udell.
Thank you.
I represent Ruben Herssein, who is here with me today. He's one of the petitioners, along with his law firm, Herssein and Herssein. In one word, I think this case can be summed up as a term that's been used recently as optics. This case comes before this court because of the violation of the Code of Judicial Conduct by the court, the trial court. It's our position that this case came before the trial court in October of 2016, when my client had filed a motion related to witness tampering concerning one witness, the chief architect of the negotiations between my client and USAA, the respondent. That witness was Katina Tomei. The previous trial court had specifically ordered two specific evidentiary hearings on the witness tampering issue. Subsequent to that, USAA hired a lawyer to represent Ms. Tomei personally, and then moved the witness tampering hearing, moved the case to the complex business system of the case, of the 11th Circuit. Judge Butchko was actually acting as the administrative judge at that time, and despite the prior administrative judge denying the motion to move the case to complex business, transferred it to complex business, which then she became the judge on the case. And the lawyer for Ms. Tomei, Mr. Reyes, actually argued at that hearing, advocating to move the case to complex business. The first thing that the trial court did was eliminate the evidentiary hearing on witness tampering. That was the first thing the court did. That was at USA's behest, even though they had previously agreed to appear for that twice. Subsequently, in June 2017, we had a hearing where we were dealing with the motions to dismiss, specifically my client individually, and my client was specifically sued personally. The court denied the motion to dismiss, and we advised the court, well, this is what's going to happen. Because of this issue, my client intends to amend their complaint, and amend a complaint, to bring in these corporate individuals personally for acting in the course and scope of their job, acting fraudulently and fraudulently inducing this contract. Subsequent to that...
Let me ask you a question.
Sure.
Would you agree that the word friend, as commonly understood, refers to a spectrum somewhere between a close relationship and an acquaintance, in general?
In general, yes, I would agree with that,
Okay.
that statement.
And are you suggesting that we should recede from McKenzie, or that it was decided incorrectly, the holding of that case being that mere friendship, as that term is commonly understood, does not warrant recusal?
I'm not
Between a
suggesting
lawyer
that at
and a
all.
judge.
I'm suggesting that in this case...
So you're not suggesting that?
The issue is the Facebook friendship is different than the word friendship. Facebook friendship is
So
more.
you accept that we shouldn't recede from McKenzie?
Correct.
It was decided
Friendship
correctly.
is
Okay.
friendship. I agree with
Would
that.
you agree that that Facebook friendship is also a spectrum that runs from close friendship, but on the other end it runs further to someone that you might even not recognize on the street or might not know?
I agree with that.
Okay.
I agree with that.
Okay. So I just analytically am having a hard time wrapping my mind around the argument that if friendship is not enough, that a spectrum that goes further in the direction of I have no connection with this person would somehow result in a required recusal or disqualification.
Well, I would tell you that friendship in the Facebook sense is actually more, because I know a heck of a lot more about someone way down the spectrum than I would know if I hadn't known them at all. Honestly, I know depending on their proclivity for posting and commenting and liking, I know that information.
You're telling me that it means the relationship is closer with someone who is at least an acquaintance than it could possibly be with someone you wouldn't recognize on the street if you saw them?
It could be, and you have that information, whereas as a Facebook friend with the judge, the other side does not have that information.
Can I just
Let
go
me
back
ask you,
to
let me ask you this. You said it could be. Okay, that seems a little speculative. What do we know here about the Facebook friends of the judge? Does the record reflect the number of Facebook friends?
No, it does not. There's no record evidence specifically as to that issue.
Well, it seems to me you might have a situation if a judge has 4 Facebook friends, 3 of them are his close relatives, and the other one is a lawyer in a case. Well, that might be something to look at.
Absolutely.
Because the fact that it's such a narrow number of friends would be indicative of something, and that the choice of the lawyer to be one of those. But we don't have any suggestion in this case that there's a circumstance like that. Now, it might happen, but what you're telling me is you have not made a record that presents that. Correct?
Correct.
So let me go to, you were on the, and we're at the issue that we're here about, the conflict issue.
Correct.
But you were suggesting, as you told the sequence of events, that there was manipulation in order to get in front of this particular judge, and then there were a series of adverse rulings against what had previously occurred, no evidentiary hearing, et cetera.
Correct.
But we're here, as I understand it, on, at least I know you've raised other issues, but whether the allegation of Facebook friends standing alone is sufficient to warrant recusal. And looking at your motion, you say that they're Facebook friends, and based on that, you have a fear that the lawyer has influence on the judge and cannot be impartial. And I think that's going back and following up with Justice Kennedy and Justice Lawson, that's the concern. I mean, I would agree that Facebook and this whole friendship and what goes on is fraught for judges with danger. You know, but we can't, with this allegation, to simply say that the friendship, I mean, the fact that someone's a friend on Facebook could be hundreds or it could be 2 or 3. I don't know if the judge was using the Facebook page to, you know, convey important information about the administration of justice. I mean, we don't have any of that. So how do you respond to that, if that's of everything should be an automatic recusal?
Well, first of all, I think at the time the motion was filed, the law in the land was this was a legally sufficient reason for disqualification.
Well, you're talking about the 4th District case. But
That
you
was-
do agree that the, and I'm concerned that there were ethics opinions out to say don't do this, but at the same time, the ethics opinion said something could be an ethical violation, but not necessarily a ground for recusal. Are you aware of the 2010 opinion that said that?
Yes, but I would say that when you have the Ethics Commission, which is a legislative created body, which is designed to advise judges of negotiating the code of ethics, and they instruct judges, do not do this. You should not do this. And then the 4th District Court of Appeal comes out and says, we agree with the ethics opinion, do not do this. I have not found one case in the state of Florida where an appellate court disregards an ethics opinion.
But if we decide that what they said is not really consistent with the legal framework that we previously had in place, then we're probably going to go with the framework we had in place.
Understood, but I believe
And you understand that JEAC opinions are not binding?
Absolutely.
And
But
they have-
if they're not binding, and if a court is faced, a trial judge is faced with this issue, with an ethical violation, they can use the ethics opinions as evidence of good faith.
So if this same person It's just, they're not on Facebook together, but they know each other. They even occasionally may have lunch together. Would you file the same kind of motion?
Absolutely not, but the issue was...
So I guess all of our problems seem to be, where is the difference? And where would you draw the line?
The difference is the specific, and as the JEC opinions say, the specific acknowledgement, the public acknowledgement that this person is a friend.
When I
It
go out
conveys
to
the
lunch
impression-
with
It conveys the
someone,
impression.
when I go out to lunch with someone, isn't that a public acknowledgement that we have some kind of relationship?
That is not forever emblazoned in the electrons in the world that anyone in the world can see, except for a
Those
person
of
who
us
is
who are
not...
not on Facebook.
If you're not on Facebook, obviously, except for if the judge is not friends with that party or litigant or lawyer.
But let's go back to the fact that you're relying on the, an ethical opinion that is not binding, of course, on this court.
Correct.
But the ethical opinion specifically says that the conduct may not qualify a judge for disqualification, but it may, at the same time, violate the Code of Judicial Conduct. You know, I would have thought after these opinions that judges would not have lawyers as Facebook friends. I mean, that's just me thinking that, but maybe this had been a campaign Facebook page. We don't know any of the specifics.
Correct.
But that's a different issue as to whether there could have been an ethical violation and as to whether just the mere allegation of the Facebook friendship should disqualify somebody from proceeding in a trial.
Well, at the time the motion was filed, in my client's eyes, that was the state of the law. That was a legally sufficient basis for disqualification. That's why the motion was filed, aside from the other two issues which we raised.
Well, but the law was a little, tell me about the Fifth District.
The Fifth District case was the Chase case. That was a case where it was a divorce case where the judge had friended.
Well, when was that decided in relation to
That was before our case,
Okay, so it was
obviously.
before your case. Well, you know, I understand your argument that there was a different issue there, but it seems to me that the court there was saying that the trial court was bound by the Fourth District's opinion.
Correct.
But then they go on and say, well, we don't really agree with the reasoning in the Fourth District's opinion.
Correct.
And for reasons that are highly relevant to this discussion. So I don't know. I mean, I can see you can argue, well, maybe that's not a holding, but maybe that is, because it's part of their analysis of what they said the trial court should be doing, and it's along that path of decision-making to get them to their bottom line.
I don't think so, because if you recall, they say...
I don't know that it makes any difference anyway,
Right.
but
in the Chase case, they specifically say the trial court was bound by Donville. Just like in our case, we believe the trial court was bound by Donville because it specifically was the issue on point. A judge, Facebook friends with a lawyer or litigant. In Chase, the judge attempted to friend, it was a divorce, and attempted to friend the wife. The wife, on advice of counsel, did nothing, and then was hammered by the trial judge.
The problem is that that on the conflict issue, which is just a question of law, if the 4th DCA or the JEAC, in their opinion, are not persuasive, then the fact that they said what they said has no relevance, at least to our decision, I don't think. And I think what I'm suggesting by my questions is I don't think that it's persuasive at all. And I've explained to you why. And what I'm hearing from you is just that, but they said it. And what would be more helpful is a coherent legal argument as to why there's a persuasive case that disqualification should be required under these circumstances,
Well,
not because...
Correct, I understand. Your position is, well, Facebook friends and friends are no different. I think that's what I'm getting from the court, and I believe that they are. And under the code, which says a judge should avoid the appearance of impropriety in all things, and that is what...
Is it improper or improper at all for a judge to make known a perfectly proper relationship? I mean, should a judge who has an acquaintance who's a lawyer only go to lunch with them in a private setting in a different city so that no one can see? Because it's going to be improper if they do it near the courthouse at lunchtime where other attorneys could see them. Is that?
I think I'm running into my rebuttal time, but to answer your question, I think the issue that the court has to grasp is the difference between Facebook friendship and regular friendship, and the specific connection of Facebook, as we discussed, as the third DCA got it wrong. So the third DCA basically says, well, Facebook chooses your friends. That's not correct. You choose your friends. You make the active engagement, this is my friend. The person accepts it.
So the relationship between Facebook friendship and regular friendship, I think those are the terms you use?
Correct.
So it's okay to have a friend, you just don't tell anybody?
I'm not saying that. I'm saying for purposes of complying with the Code of Judicial Ethics, specifically, you're trying to avoid the appearance of impropriety. So you don't want to have electrons emblazoned in the world for everyone who's on Facebook to see, except for the other side.
But, you know, again, I'm not on Facebook, so, but I know something about it from reading the case, the materials here, and from what you presented. So it seems to me that the reality of Facebook friendship is that Facebook friends frequently are friends of a friends of a friend of a friend of a friend. I mean, it's this network, and it extends out. And so the idea that somehow participating in that networking arrangement somehow establishes the kind of relationship with anybody who happens to come into it that would result in disqualification just is not consistent with what our case law has said about traditional friendship.
Right, and that's the difference. It's different. It's not traditional
I
friendship.
agree, it's different.
Let me ask you this. And this was the follow-up opinion from the JEAC. The question was posed, I don't remember exactly, but something like, if the judge posts in their profile that they are a judge and that they are indiscriminate in accepting friends and will accept anyone with whom they have a connection remotely, and the fact that someone is a Facebook friend doesn't mean that they would even know them. If that's part of the Facebook page, then why wouldn't that, now the JEAC said that wouldn't cure the problem, but why wouldn't it cure the problem
Because,
that you perceive? For somebody who doesn't understand Facebook and how it works.
I think it's the very implication and the selection to the exclusion of others. If anyone could friend the judge and the judge could friend anyone, then I think you're correct. But that's not what the case was here. At the time the motion was filed and at the time we discussed this, it was a friendship, offer, acceptance deal. The other side would have no knowledge of that.
You said that it's not true that anyone could friend a judge and a judge could friend anyone, but that is the way Facebook works.
Correct, but you have to make that connection. And the point is, to avoid the appearance of impropriety, you cannot make that connection to the exclusion of the other side. Thank you.
Okay, I'll give you some time. for
Thank you,
rebuttal.
Judge.
You got a little more time.
Good morning. May it please the court. I'm Suzanne LeBrit, and it's my pleasure and privilege to represent USAA today. With me is my colleague Amy Bussell, who worked on the brief. We believe the third DCA properly held that the fact that a judge is Facebook friends with a lawyer for a witness or a potential party without more does not provide a basis for disqualification.
Let me ask you a question about going to lunch with a lawyer. We all, when I went on the bench, I was had an appellate judge. He took me to lunch, and somebody came over and had a question about some legal matter, and I was about to answer it, and he said, you're about to be a judge, you're in a different position. Going out to lunch with lawyers is certainly nothing that we would prohibit, but I'm pretty sure that lawyers, when they know they're going to be appearing before a judge, will avoid that kind of public, that they're having lunch, say, during the case. right? We'd agree that during the case, we wouldn't want lawyers that appearing before the judge to go out to lunch, correct?
Oh, yes, Your Honor.
Okay, so there's something different about what may happen before a case and then what happens during a case. So the question, we looked at all the different states about what judges should do, is that California talks about, well, if these are, and Oklahoma, if there are lawyers that are regularly appearing before the court, that is a different situation. You know, someone's a corporate lawyer having a friend who is, it may be different. So do you agree that although there may not be a hard and fast rule, that this Facebook friendship is not quite as simple as, oh, well, someone might have thousands of friends, so it's not an issue for a judge to have lawyers as friends? I guess is my lead-up question.
I'm following your question. I agree with the start point, which is that if I'm appearing before this court, I should not have lunch with one of you after this argument. That would probably be not a good thing. And I understand what you're saying about the fact that the Facebook relationship would indicate that there's a possibility to have an electronic lunch, if you will. I would respond to that by pointing to Judge Logue's analysis in the third DCA, in his opinion for the third DCA, where he talks about, and I would tie that to what Justice Kennedy raised in the discussion earlier, that we don't have any record of what this judge's Facebook account looked like. And what Judge Logue explained is that people sometimes have thousands, hundreds of thousands, and may not even know who their friends are.
Well, but that's really, again, I know that, and I thought Judge Logue wrote a very good opinion and solid opinion, but the reality is that still you may get thousands of friend requests, but there is an affirmative decision as to whether you're going to accept that friend request or not. Am I correct about that?
Oh, yes. And I also would point to the court, and I think this is recited in Judge Logue's opinion, Facebook has been around for a little bit longer than 10 years. A lot of judges have come on the bench since then. People, I'm not particularly Facebook literate myself, but I understand that you can sort of randomly Facebook does make suggestions, as Judge Logue told us, about people that you know, and I believe that in our record, which at A43 is the printout of this judge's Facebook page, and it shows that whoever pulled that printout had 10 mutual friends with the judge. So we know that the judge had at least 10 friends and a few more that are shown on that page. And I don't think that people necessarily, or when they, for example, are appointed or elected to the bench, would particularly if they were someone who had thousands of friends, would necessarily think, well, I've got to go back and delete.
Well, we ought to, but that is something very different, because there are a lot of ethical opinions that talk about, Connecticut does, that when a judge who might have had thousands of friends when she wasn't a judge goes on the bench, you don't think there's an obligation to look at your Facebook page to see who these friends are? I mean, so let's get back to, but, you know, the problem is that we're here, there was an ethical opinion, there was a 4th District case, but I think you're on more solid ground by just saying this allegation that a Facebook friend could be anything from a distant acquaintance to a long-lost relative to a part of your high school class to somebody that you are close with, and, you know, is not enough.
Well, and I would respond to that 2 ways. I think that Justice Lawson asked the right question, which is if you all are going to change, in order to rule the way that the petitioners would have you, you would need to receive from McKinsey. And
well, I don't really, you know, Justice Overton, whether it was McKenzie, talks about how in small counties, if you have friends that are lawyers, that it's you're part of the same bar association. But the reality of the Facebook world is a judge has a choice to not have a Facebook page and not have lawyers as friends. And that's what all the Judicial Ethics Advisory Committee opinions said. And so I am still concerned that a judge in light of that, as opposed to seeking a change in the opinion, would continue to have a Facebook page when they become a judge with lawyers that might appear before them. So I think in this case, you're on solid ground, but I'm not as, I'm more concerned than you seem to be about whether a judge can do certain things to ensure that what's on their page is, does not have lawyers as friends.
One thing, and I'm not to be contentious over this, what I didn't see in the JEAC decisions from 29 and 2010 was an admonishment or a requirement that a judge who is either on the bench or will be taking the bench should delete their Facebook account or police it to ensure that the only people that they are friends with are non-lawyers. And that's sort of the practical effect of one of the practical effects of accepting these positions. And I think that, and I'm not sure which justice asked this question, I think it was Justice Quince. If we accept the proposition that Facebook friendship ranges from a good friend, my father, your best friend in life, to, LeBron James and I are friends on Facebook. He probably couldn't pick me out in a lineup. If we accept that proposition, then we have to think in terms of what is a real friend that we know.
Did he post anything after the game last night?
I missed the game. That if we accept the proposition that friends in real life are somewhere on that continuum, then any time a movement for disqualification alleges that the judge is friends with lawyer and judge did something else, which we have other things that were alleged here that we haven't spoken of, then we have to get behind that. And that would result in what Justice Barquette in her her concurrence in McKinsey said, which is, we will now be choked with infinite motions to disqualify based on the fact that a lawyer may be friends. And if
What about if you live in a community and some of the people who are not lawyers in that community are your friends, and one day you happen to have one of those people in your community who is the plaintiff or the defendant? It seems to me that this rule would then extend, if we accept the rule, that it's an automatic disqualification if the judge is Facebook friends with a lawyer. Wouldn't it follow that the judge would also have to be disqualified if some friend, Facebook friend, ends up being a litigant?
I think that's an excellent question, Justice Quince, and I think it's been spoken to several times in the law from the other jurisdictions. I know Justice Periente has read it. I looked at an ALR article and an NCSC compilation, and that's been one of the concerns, is judges who are friends with family members of lawyers who appear before them. It becomes exponentially impossible to manage, is the short of it.
My concern, I used to have a professor in law school that anytime you asked him for a legal question, he would always say, it depends.
I'm sorry,
It depends. And I think that appropriate here, I think we can start with the proposition that being a friend on Facebook by itself, standing alone, may not be sufficient for a recusal. However, it depends on how that friendship and how the conversations on Facebook are used. Example, let's say I'm on Facebook, and I'm not. My wife would not allow it, okay? So I'm on Facebook, and I have 500 friends, right? People I don't know. And then one day, say I'm a circuit court judge. I make a ruling. And all of a sudden, I get like 150, 200, way to go, judge, great ruling, I agree with you 1,000%, you're the best judge on this planet, so on and on and on. I mean, I can't stop that from happening, but yet these are things that I'm reading as a judge, telling me the approval that people have about what I did. I mean, see what I'm saying? It can get to a point where it does have some impact.
I think we can answer that in a very general but very well-established precedent of this court. And it is recited in the McKinsey opinion and multiple other decisions this court has issued on disqualification. The bottom line here is this court must and does assume that judges will abide by their oath, that they will follow the canons of judicial conduct as they have sworn to do and perform their duties impartially and diligently. We can't have a system that is based on, that operates based on the suspicions of, you know, sort of the outliers. And if your judge...
Also, we must have,
I'm sorry?
should we not have, as a system, the parameters within which human judges must operate, including actions and conduct that create impressions on other folks. Those who are frequent contributors and participants in Facebook, which I am not, may view it one way, that, oh, this is no big deal. Those who do not participate because they fear exactly what's happened today is that they have an impression that's created, whether it is one that's absolutely 100% based in fact, but it is based upon their encounters in an action. So what's wrong with drawing lines where there's something on that's so nebulous that it depends, that we not have some more bright lines in connection with this?
Well, that's certainly within the purview province of this court's authority to make those types of rules. But
if all judges were saints, then we wouldn't be having all the cases that we have coming over from the JQC. And they're coming over on a weekly basis, my friend.
It just seems to me also that a judge needs to minimize the opportunities of someone wanting them to be disqualified.
yes.
And it
I would-
seems to me that when a judge is on Facebook or any of these medias that I'm not familiar with, that you then run the risk of disqualification. I mean, if this motion had more in it than just that the judge and the lawyer were Facebook friends, but they also on Facebook said such and such to each other, and whatever it may have been, then you run the risk of having multiple motions for disqualification for any number of people.
So I would respond to you with a real-life analogy of lawyer friends. And we would say that Judge Buchko had been at a restaurant in Miami having lunch with Mr. Reyes 6 months before the hearing, the events that happened here. And they were convivial and just enjoying themselves. But that's all they knew. Would that be enough to disqualify Judge Buchko if that, instead of saying Facebook friends, it was that I saw them 6 months ago having lunch? I don't think it would be under this.
But here's the thing. You said that you hope that, or you expect judges to follow ethical rules. In 2009, the JEAC said the issue is not whether the lawyer actually is in a position to influence the judge, but instead whether the proposed conduct, the identification of the lawyer as a friend on the social networking site, conveys the impression that the lawyer is in a position to influence the judge. The committee concludes that such identification in a public forum of a lawyer who may appear before the judge does convey this impression and therefore is not permitted. That's 2009. In 2012, the 4th District said unequivocally it's grounds for recusal. So now we're really talking about, okay, so maybe life has changed and now Facebook, although it's certainly in the news for other nefarious reasons, is a great thing. And it's a great way for judges to ensure they're out in the public. But this judge and this lawyer were operating at the time under the ethical opinions of the JEAC and the case law of the 4th District. So I'm taking issue with your comment that we expect judges to act ethically. At the time of this case, it wasn't improper for someone to have lunch with a judge 6 months before, but it was improper for them to be Facebook friends at this time. So how would you answer that?
I would answer that by saying, and I think it was Justice Kennedy who raised this, or maybe Justice Lawson, that while the JEAC opinion, the advisory opinion of the JEAC might have given a basis for an ethical violation, and I would submit a technical ethical violation, it would not necessarily have provided the basis for a disqualification.
But I'm saying, but I agree that the JEAC doesn't in itself provide for that somebody has violated the code, but it's pretty strong evidence. I mean, I know when I read this in 2009, I understood that I would not have a Facebook page for this very reason. It's fraught with danger.
I apologize, I lost my train of thought.
Well, you're saying that it doesn't mean that she violated the Code of Judicial Conduct, but you know, Miami-Dade has a lot of judges and they have a lot of lawyers. Now, maybe all of them are friends with one another on Facebook. We don't know it, but the better part of discretion would have been, in my view, to have disqualified herself. Now, again, maybe the 3rd District is right because of everything we've said today, but it does concern me that this occurred.
I wanted to answer, and I got lost in the dialogue, a question about this that I think is relevant to the inquiry that I think you're concerned with, Justice Periente, and it is that, I'm standing on what I said just now, that the JEAC opinion does not necessarily form the basis of a disqualification requirement. One of you earlier pointed out that we know nothing about this judge's Facebook page. We don't know enough to know what kind of friend, if any, it was. And I understand, I'm accepting your premise that being a Facebook friend could itself, under the JEAC opinion, but under that opinion, and the minority which grew between the 2009 and the 2010 opinion, said that it's impossible to distinguish between a real life friend and Facebook friends, which are more attenuated in general, and we don't know enough to know whether this one it was an accepted of 1,000 friends from 6 years ago or some other thing. And so unless the court is going to essentially recede from McKenzie or severely undercut the notion that judges can be friends in real life with people, the only way that judges can for sure know that they're not able to have a Facebook account, or if they are, it can only be with their families, who hopefully don't have any lawyers in them that might appear in front of that judge after the 3rd degree of consanguinity. And certainly that's something this court can do, but is it something that makes sense and would allow for in 2018 and in the future for lawyers to be able to practice in front of judges and not have a whole court dedicated to disqualification motions on Facebook friendships? That's our position.
Well, I'm missing that. Would you say that again?
I don't know if I can say all of that again.
Well, no, you're painting a portrait of doomsday is what that last statement was. Is that, can you imagine that you can't try cases because you're going to be trying a disqualification? Why is that?
What I'm saying is that unless you make a bright line rule that judges can have no Facebook accounts, that the scenario of it depends, Justice LaBarga, it becomes, and Justice Barquette said this about friends in real life in the McKenzie opinion, and I would encourage on that point to look at how the words that she used.
But here is the problem, and you're out of time, but you've created an impression that having a Facebook friend is, as a lawyer, would be prohibited. No, lawyers that are possibly or likely to appear before the judge, number one. there's nothing that prohibits a judge from having a Facebook page. And you're also, to me, missing the point that Facebook can have some very intimate details of what the judge, going on vacation, there's a picture of her, she's in a cowboy hat. I don't, again, so what you're saying is that since you agree without more, it's not enough, that you're going to put a burden on the lawyer to start to search into the private Facebook page of the judge or the public Facebook page to come out with whether this is somebody that has 1,000 friends or only 100 friends, to look at what she's posted. And that to me seems more intrusive than just having, a bright line rule.
And to answer your question about the looking into the judge's personal life, judges who have friends in real life also have opportunities to talk about vacations, wear casual clothes, and that Facebook doesn't change that. And they have the opportunity to communicate privately. So there isn't really, I would submit respectfully, any difference between that. And I would close by saying, and I know that this is what the JEAC was very concerned about, that there's a selection process. Well, there's a selection process for being friends in real life too. So we would ask that this court adopt the decision of the third DCA and deny the petition.
Thank you.
Thank you.
I'll give you an extra 2 minutes.
Thank you, Justice Labarga. The comment was made that there was no record for the court to distinguish. And one, we couldn't get a record because we are not Facebook friends with the judge. We cannot get that information as a non-Facebook friend, whereas the other side, the other lawyer, has all that information. So we couldn't develop a record. And if we wanted to develop that record, dollars to donuts, discovery would be served trying to get that information, which exposes the court to additional burden, which they really shouldn't have. And I think we're not saying judges can't be on Facebook, although none of you are. And no justice here is. I don't know about Justice Polston, but I assume he's not. Just don't be Facebook friends with lawyers who appear in front of you. It goes back to the word I came up in the beginning, which is optics. It just doesn't look right. Because
So let me ask you this, what
yes.
would happen then if a lawyer, a person asked the judge to be friends and did not identify themselves as a lawyer, and the judge accepted them as a friend, not knowing that the person was a lawyer? Where would that lead us?
Well, I think the judges have to be vigilant on protecting their online identity. I think they have to manage that, just like anybody else does, but judges are held to a higher standard because obviously the appearance of impropriety is bedrock in the law, and if that is exposed, then my client has no ability to get a fair trial when he has that in his mind.
Well, yes, you said that you couldn't find anything out about this Facebook page, but you attached to your motion a page that showed at least...
Correct. The only thing that we could find was the fact that they were Facebook friends based on how it was disclosed by the judge, but we could not determine whether there are communications between the
But
two.
can you determine how many friends she had? I mean, if you have a Facebook page, if you're a Facebook user, can't you go on and look at other people's Facebook page?
Going back to Justice Labarga, it depends because depending on the privacy settings that certain people have, you can say no one can see who my friend is or everybody who can see who my friend is. So it leads to a quagmire of information and that this judge at the time, and going back to what happened at the time we filed the motion, the state of the law was this was a legally sufficient grounds for disqualification. Just like in McKenzie, where the third DCA had ruled on the issue, which was a contribution issue, then it went up to the Supreme Court. The Supreme Court said, we're going to take the different view, but at the time, the trial judge was correct and should have disqualified themselves. That's exactly what we have here, except the trial judge did not disqualify themselves.
Let me ask you a question that's only partially hypothetical. When I was a trial judge in the Ninth Circuit in Orlando, and most of the time when I was a DCA judge, I ran in a running group that was not lawyers, but there were a couple lawyers that were part of that group. It would be 50 or 60 people. We'd leave at the same time on a Wednesday night. We'd run through downtown Orlando. Now, there were times when one of those lawyers might come up and we might chat for a few minutes and then go off, and then I'd be chatting with somebody else. But it was pretty darn public because people would be leaving work late and that kind of thing. So it just wasn't too long, because I was doing that for years, where pretty much people knew or could find out that lawyer who might appear in front of me was someone who I ran in a group with on a regular basis. So that there's a connection, a pretty public connection in the non-electronic world. Would the fact that you knew that give you an opportunity to conduct discovery, to discover the rest of the relationship, if there is any?
I don't believe so, Justice
Okay,
Lawson.
and
However,
how is that different than
I think
Facebook friendship?
that's the discussion that the court's having. What is the difference between Facebook friendship? And based on our reasoning and the fact that the time the motion was filed, that was the state of the law. My client had a right to rely on that when he filed the motion. If the court's going to create a new rule which says it's okay, it's not a grounds for disqualification, I don't think my client should be penalized for relying on the law and relying on
But
two
you say
JEC
create a
opinions.
new rule. I mean, it's conceivable that what we'll say is that McKenzie requires a result that's adverse to you. So the rule is a rule that flows out of McKenzie. It's
Understood.
not a new rule. It may be inconsistent with what other people have said, but it's consistent with our rule that flows out of McKenzie.
Understood, which is the premise that Facebook friendship is different than friendship. And that's really the issue for the court. So it asks the court to grant the petition for my client. Thank you.
Thank you for your arguments. Your friends are leaving.